Topics ranging from gun rights and private property laws to foreign property confiscation.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
The highest court in the land is now looking into overturning Hawaii's strict gun laws.
That's right. The highest court has agreed to hear arguments on a challenge of the laws that limit where concealed carry is allowed.
Cite on a Hawaii gun law that's under review by the nation's high court.
The Supreme Court just granted emergency review to a Second Amendment case that will directly address whether several states intentionally passed laws designed to defy and nullify the court's previous landmark ruling, and this decision breaks the justice's long-standing tradition of avoiding interlocutory appeals that haven't been fully litigated. 5 states, including Hawaii, California, New York, New Jersey, and Maryland, responded to the Supreme Court's Bruen decision by enacting new concealed carry restrictions that essentially created a presumptive ban on carrying firearms on any private property open to the public unless the property owner gives explicit advance permission. But here's what makes this case genuinely remarkable. The Trump administration's Department of Justice and Attorney General Pam Bondi just filed a brief supporting the gun rights challengers and explicitly called on the Supreme Court to strike down these state laws, which likely played a decisive role in the court's unexpected decision to grant review. The Ninth Circuit Court of Appeals upheld Hawaii's catch-all property ban by relying on 2 historical laws that the challengers argue have nothing to do with the current restrictions, one enacted by a former Confederate state specifically to deny freed slaves their rights, and another designed to stop poachers from hunting on private land that was closed to the public. Once you understand what Hawaii conceded at the Ninth Circuit that trapped them into this Supreme Court review, why 45 states respect concealed carry rights on private property, while just 5 outlier states created these bans in direct response to Bruen, and what the oral arguments scheduled for January will likely reveal about how far states can go in restricting constitutional rights they disagree with, you'll realize we're watching the Supreme Court prepare to draw an even sharper line about state defiance of federal constitutional rulings than they did in Bruen itself. The Supreme Court recently granted certiorari review to what's being described as the next major Second Amendment case, and once again the case deals directly with state concealed carry laws and what appears to be deliberate defiance by certain states after the Supreme Court issued their 6-3 ruling in New York State Rifle and Pistol Association versus Bruen. This new case has now been scheduled for oral arguments at the beginning of next year, representing a remarkably fast timeline for Supreme Court review. The case is officially titled Wolford versus Lopez, and it deals directly with state laws that were passed in what challengers characterize as direct defiance of what the Supreme Court clearly stated in the Bruen decision. States including New York, New Jersey, California, Hawaii, and Maryland passed what gun rights advocates describe as hyper-restrictive concealed carry laws immediately after the Supreme Court issued the Bruen ruling. The Hawaii case, called Wolford versus Lopez, sought emergency Supreme Court intervention, which to the surprise of many court observers was actually granted review by the justices. This constitutional challenge revolves around a preliminary injunction and the Ninth Circuit's finding that states and their catch-all public property bans are legally permissible under the Second Amendment despite Bruen. Recently, to the genuine surprise of many observers, the Trump Department of Justice and Attorney General Pam Bondi actually stepped forward in support of this constitutional challenge, and they formally called for the Supreme Court to grant review to examine these state bans on concealed carry. That federal government support appears to have paid off significantly. The Supreme Court, in a very surprising turn of events, decided to grant emergency review to this case. This grant of certiorari actually breaks the Supreme Court's long-standing track record of avoiding these types of interlocutory cases, these emergency appeals, which are not on the final merits after full litigation. The Supreme Court has granted review to this case and has now scheduled oral arguments to take place on this constitutional issue at the beginning of next year on January 20th. The parties are currently submitting their legal arguments to the Supreme Court, explaining why the court should rule in their favor. For those not closely following this litigation, the Wolford case is a constitutional challenge to Hawaii's new laws on concealed carry that were passed in direct response to, and what challengers claim is defiance of Bruen. This Hawaii law, like many similar laws in other states, including California and New York, attempted to add significantly more restrictions to concealed carry permits and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express advance permission for the individual to do so.
It's out of Hawaii. It sounds like that it has to do with concealed carry laws.
The law the Supreme Court justices have their eye on is one that prevents people from carrying guns in certain public places.
The justices will decide if it violates the right to carry weapons in public for self-defense.
Businesses are welcome to put up signs that say this is a gun-free zone, but if you don't, then it's expected that you are able to carry on that property.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
Plaintiffs in this case sued the state of Hawaii to strike down that law as unconstitutional. On initial review, the federal district court issued a temporary restraining order, which was later converted to a preliminary injunction blocking enforcement of the law. That preliminary injunction was then appealed up to the Ninth Circuit Court of Appeals and was reviewed alongside California's nearly identical concealed carry ban, which is a law implemented in California that's essentially the same as Hawaii's with only minor variants. On appellate review, the Ninth Circuit upheld the catch-all property ban enacted in Hawaii and reversed the preliminary injunction that had been issued by the lower district court. The Ninth Circuit relied on older historical restrictions related to hunting and private property rights to actually support that statewide concealed carry ban in Hawaii. After that adverse ruling, the plaintiffs then requested that the Ninth Circuit en banc panel, consisting of all active judges, review this case, but the circuit denied rehearing. They didn't even want to take another look at that panel ruling. That denial led this case to then seek emergency Supreme Court intervention through a petition for certiorari before judgment. Like previously mentioned, this case faced what seemed like a difficult road ahead because the Supreme Court has traditionally not granted review to preliminary injunction cases or these interlocutory emergency appeals that haven't been fully litigated to final judgment. However, the United States government actually supported this case and actively pushed the Supreme Court to grant review to this constitutional issue, and the Supreme Court broke their normal tradition and actually granted review to this case. That grant is likely because of critical concessions made by Hawaii at the Ninth Circuit and because of what some describe as a legal trap that the plaintiffs strategically set with the support of the United States government. One of the interesting strategic arguments that the Trump DOJ brief made was that the Supreme Court should not avoid this case by sending it back for further development. They argued the court should take it on an emergency basis because Hawaii had already conceded that nothing else needed to be developed at the lower court level. Hawaii told the Ninth Circuit that expressly, so there was no legitimate need to kick this case down the road and wait for it to further percolate in lower courts. Instead, it was time for the Supreme Court to step in and definitively review this constitutional issue. That federal government argument was likely critical to breaking through Hawaii's procedural arguments that the petition should be denied so lower courts could continue developing the record, because Hawaii itself had conceded that further factual development was not needed at the Ninth Circuit level. Ultimately, the Supreme Court disagreed with the state of Hawaii's request to deny review and actually granted certiorari to this case. The question the Supreme Court will consider and address in this case is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. That means the Supreme Court will directly address these catch-all property bans that were passed in what challengers characterize as defiance to the Bruen ruling. It's also very likely that this Supreme Court decision will dig substantially deeper into the prior Bruen decision, outlining more comprehensively and developing more thoroughly how the constitutional analysis needs to be applied post-Bruen. This case will now be argued before the Supreme Court on January 20th, when oral arguments have been formally scheduled. Recently, the plaintiff in this case, Wolford, submitted his legal arguments to the Supreme Court explaining why the court should rule in his favor. In that merits brief, he states that 45 states respect the constitutional right of their citizens to carry arms for self-defense onto private property open to the public. 5 outlier states, Hawaii, California, Maryland, New York, and New Jersey, have allegedly defied Bruen by enacting a new default rule that bans carry by permit holders on private property unless explicit permission is obtained from the owner. These same 5 states previously had may-issue discretionary carry permit statutes of exactly the type that was invalidated as unconstitutional in Bruen. Each of these states reacted to the Bruen decision with what the brief characterizes as defiance. enacting legislation specifically designed to thwart the general right to carry that was recognized in Bruen. The plaintiffs point out that Hawaii enacted some of the more egregious carry laws that were passed post-Bruen. All of these states implemented these restrictions in direct response to what the Supreme Court ruled. They did not want to transition to shall-issue permitting systems, so they did everything they could to restrict access to concealed carry through other mechanisms. The plaintiff's brief goes on to point out that the Ninth Circuit found sufficient historical support in just 2 outlier laws separated by almost an entire century. One law was enacted by a former Confederate state prior to readmission to the Union, and for the explicit purposes of denying freed slaves their constitutional rights to bear arms. The second was enacted decades later to deter poachers from hunting game on private land that was closed to the public, not open to it. The brief argues that both historical laws fail to meet Bruen's how and why analytical framework for determining whether modern restrictions are consistent with historical tradition. Rather, Hawaii's law was enacted for the explicitly stated purpose of discouraging trained and vetted permit holders from exercising Second Amendment rights that were newly recognized and protected in Bruen. Hawaii's law thus illegitimately criminalizes the exercise of a fundamental constitutional right without constitutional justification or legitimate historical support. Therefore, the plaintiffs argue the Supreme Court should reverse what the Ninth Circuit ruled. Legal briefs are now being submitted to the Supreme Court in preparation for oral arguments that will take place in January in this case. Soon, Hawaii will file their response brief defending the law. There's also widespread anticipation that numerous amicus briefs will be submitted to the Supreme Court from various interest groups and legal organizations on both sides. There's likely going to be an amicus brief filed once again by the Trump Department of Justice in support of the plaintiff and against the state of Hawaii's position. Many court observers also anticipate that the Trump DOJ will probably request permission to participate directly in the oral arguments before the Supreme Court. If granted, you would have the Trump Department of Justice arguing before the Supreme Court that these types of concealed carry laws violate the Second Amendment, which would be a significant shift from typical federal-state relationships. That's something legal observers will be watching closely. This represents a huge Second Amendment case moving forward with significant implications. This is enormously important for Second Amendment constitutional analysis going forward, and it will be fascinating to observe how the oral arguments develop, what questions the justices ask, and what additional doctrinal language the Supreme Court might include in their final decision that could impact other Second Amendment cases currently being litigated across the country. That's it for today, folks. See you in the next video.